Okay, good afternoon, ladies and gentlemen. So, in the last class, we have surveyed the intellectual property rights, and I intended to expose you to some more basic rules about the national laws and international response to deal with counterfeited goods and also pirated products against the copyright holders, kind of absurd or in some cases transgressing nature, which would contravene our usual attribution as a quasi-property right, would be serious. And actually, thrift is one of popular source of a contention in WTO context. You see, actually, it involves the kind of a notion we emphasize highly about fair play, or others. Free riders claim often appears no sense of justice. However, there would be some concern to impose a kind of balanced understanding about the nature of as a common asset and a quasi-property right. How do you consider it deserves a due protection in terms of duration of that right and also other factors in public policy concern? So, we now see some of more points about copyright protection by exploring the cases left undealt in the previous class. I forgot to bring my USB, so you now advised to refer to the printouts delivered in the last class. You see the case Metal versus Walking Mountain Productions, decided in Ninth Circuit 2003, and I also like to bring your point about a parallel imports, the gray market concern, and the case actually be viewed in which entails the provisions in conflict about legal consequence. The statute the United States Congress enacted what it called Copyright Act, Section 602, and other clause, Section 109A, would come into conflict in your deliberation in some aspect. However, how do we give a proper interplay between both two clauses would be concerned in the case titled Columbia Broadcasting System versus Copier Music Distributor, decided in 1983. And then we see some of practical points presented in the box about hiring a copyright employee, for example. I mentioned previously the collective right to copyright, and often the concept provokes some of difficult points about legal response, as you see, between the copyright holders in collective frame and also the copyright in an individual context. then we may survey some other points in general overview, which concerns a foreign intellectual property laws and foreign trademark law and foreign patent law. And also we have some points about the regional arrangement, as you see on pages. The North American Free Trade Agreement. So the protection of intellectual property rights, as I have introduced, they have nexus in high profile with the export and imports in the international economy. So the policymakers may bridge the justice, which is the universal and often exclusively dealt within the domestic jurisdiction to the international covenants. So the TRIPS agreement is actually notorious and universal, which would be in conflict and in need of a compromise with regional agreement in some cases. So we have that quality in this class about a multiple context of a norm. So the policymakers and adjudicators about dovetail laws, and also often the commercial diplomats in the government need to have the mind and ideas about the multiplicity of norms in his sphere of responsibility. So the TRIPS agreement imposes a duties and obligations in, of course, in the form of a multilateral trade agreement. So the national authority has to respect the commitment. So they are obligated to institute the level of a protection by ways of substantive law and also the kind of a adequate procedure to respond with a counterfeit goods and pirated products. So upon breach of that provision, it may elevate into kind of a trade dispute among the parties. So the controversies would be very intensified in new advent of a WTO role in international trade relations. So massive of cases and what labors and works from the trade lawyers centralized to present the case in their favor. And also you see the structure that WTO may operate. And we may have that concern in other class, so I also make it on the list. You see intellectual or public law on trade, titled International Commercial Law. So now the WTO rule would be very powerful. To see, it takes the form, to begin with the words, we recommend that your domestic measure is in contrary status with the WTO commitment, so must be abolished. So the literal expression of the WTO rule will not be the same when you encounter court order or so it actually be seen as one of recommendation and in compliance with general theory of international laws, state sovereignty and others. However, its practical effect would almost be binding. As I've said, unanimity rule to endorse the WTO decision were abolished when the WTO entered into new force as a matter of international trade. Instead, we see quite a perverted method in interplay with a WTO adjudication dispute settlement mechanism. See, so reverse consensus system is looted now and practiced for 15 years. 1995, so almost 20 years. So now the judicial character of WTO is highly enhanced in high contrast with the former form of a GATT. You see, GATT is actually a political nature of organization, which could be well juxtaposed to new form of WTO. And also, now the high profile of interdependency concerning the international trade or economy often mandates the WTO organization could be the member states of WTO organization have to be bound by the decision. So, in non-compliance with WTO measure or decision would often mean it's a threat to the membership. So, how do we insist on our economy to survive? And also, there is a systematic system to sanction the losing party in WTO. So there's an option to comply with the recommendation of WTO panel's decision, or must suffer from retaliatory measure to compensate for the prevailing member state. So it is very intrigued in the system and institution now will be perceived as one of most enhanced form of international organization, I have said. In my viewpoint, it would most be analogous to national system in terms of enforcement and also governance. We may emphasize other institutions, however, it often would be fair. So the economic matters would be the point, an area that now the global states may have more probability to agree upon and consensus negotiation. In other areas, for example, national culture or education, and politics, it would be actually resilient to have a uniform fashion of a settlement. So International Court of Justice is most general form of a forum we may employ to be submissive to international authority. However, we see some of high stalemate, practically, not legally, about this role, and also it may be locally be evidenced, as we are reluctant to bring the case to the International Court of Justice about Tokto problem, or the Sea of Japan, East Sea. The island is not and has long been contended by two adjacent countries, Korea and Japan. However, strategically, as I've said, we don't need to respond. However, how do you perceive it in terms of international justice? So actually, in overview of this class discussion, you have some idea to link the discussion to the TRIPS agreement. And locally, we have many cases to have potential that could be universalized to govern the issues or contentions involving intellectual property rights. And also the system and level of standard was espoused by a U.S. court often be influential and may be shared in terms of universal justice. And also for the private enterprises, the choice of law often lead to the destination of U.S. copyright law or copyright law and others. So it is actually and practically important to know the basics of the rules and laws. So we have types of intellectual property right, beginning at a copyright and patent protection through the trade secrets. And the metal case involves the copyright dispute between Metal Incorporation and Working Mountain Productions. Thomas Fawcett, who would be alleged to be popular artist, actually misappropriate the Barbie image to present 78 photographs in a pejorative way. So dereliction and the kind of a sexualized position were produced to capture the viewer in that impression. And also it would be absurd in various points about the image of Barbie. Barbie is the subject matter. Metal Incorporation obtained the copyright. So it deserves due protection, as the statute spelled out about the rights and duties concerning copyright. So it was used in interplay with a public notice, a public disclosure, and also obtain a fame about that transformed image of a Barbie. What do you have an impression about Barbie? So it is a popular image we often encounter throughout routine days. So it actually has been more. So the expression, which is alleged artistic and deserve a First Amendment free speech protection, very be distorted. However, we may not disregard entirely about its value of expression. Social criticism and public comment may be implied by presenting the image. So it is keenly related with the First Amendment rights in first instance. And also, it is strictly forbidden if the expression falls within the class other than a commercial. So if it contains a political value in some cases, we need to shape some of apply and enhance a degree of a protection. So, Malted Baby, in this case, was alleged to infringe the copyright of a metal incorporation. So, it to be vindicated in court ruling. You see the case highlights in the box. We see later shortly about the essence of this case. So, on August 23, 1990, a metal filed this action in the United States District Court for Central District of California against Force-Fight, alleging the Force-Fight food chain Barbie series infringed metal's copyrights, trademarks, and trade dress. So, as you learn in the last class, we often rely on 4 factors in test to determine if it falls within the exception. What are your fair use? The fair use to be protected as an exception, or it falls outside the scope, then merits the finding of infringement, trademark. What are those factors? The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. And second, the nature of the copyrighted work. And third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And fourth, the effect of the use upon the potential market for or value of the copyrighted work. So the court often invokes this test in step to reach this conclusion. This case also will see the context, you see. And the 4 factors are actually independent, but in overall point of consideration may interact to vitiate in some aspect to be traded off by others. And the court saw most importantly the first point, the purpose and character of the use. And for actually the parodist may claim fair use. So some of the elements of prior author's composition to create a new one, the lasting part comments on that author's work. So whether it is transformative or merely supplement with the original work is a critical point of test to define the purpose and character of the use, and how much the varied form of a subject matter may be increased in quality and what impression, whether it in viewing a transformation, is it highly transformative or transformative to make it entitled protection, or may virtually the same to mislead public into confusion of both images. So, one may feel about his message, whether he's wrong or right. In this case, whether his messages are powerful or banal. His photographs parody Bobby, and everything material star has come to signify. Undoubtedly, one could make similar statements through other means about society, gender, roles, and sexuality, and perhaps even social class. So, actually, the presentation of image may constitute some of a artistic expression about a social agenda, as you see. So that is sure preserve the First Amendment rights intended to protect. Bobby and all the associations she has acquired through Martyr's impressive marketing success conveys these messages in a particular way that is right for a social command. By developing and transforming associations with Martyr's Barbito, Forty has created the sort of a social criticism and parodic speech protected by the First Amendment and promoted by the copyright act. We find that this factor weighs heavily in favor of a force. So often, the First Amendment right is a pillar to structure the government in the United States, and diversity, and is a central concept. Often, the public policymakers and adjudicators may deliberate on. That is because the national circumstances and attributes could be made distinct from other contexts of nation. For example, we are unitary form of government and same ethnic background, as you see. However, it is interesting to see some of similar context recently developed by social critic in Korea. You see what the president incumbent in this administration also has once been tarnished in some sense about his public image. And also Moo Hyun-no, who was that? A sad story about that, committed suicide, also was depicted in very absurd way about his public image. Also, Myung Bang-ri is often now be considered a permissible and a social practice also in Korea. The practical needs to promote the freedom of expression would be more serious in the context of the United States as diverse, the country of diverse elements. Anyways, actually so. And also diversity alone would not be sufficient as we investigate deeper into the nature of a problem well, not exactly problem, it is kind of source of competitiveness and often multiculturalism or others. One metaphor often espoused to manage the public organization and workplace in spanning through the private forms. That is the matter not to be ended. So the public policymakers strive to mend the flaws and weaknesses diagnosed in contemporary context. As you see, that could be progressed in some period of time, and also may be spoiled worse way. So it is actually not a matter of progress of time. It involves the intrinsics of humanity. So the attention, public attention is actually important. One notable example involves the high level of poverty in the United States, and the income disparity now be transposed into poverty concern. So the marginalized group in the United States has now been serious. So is that diversity? And also diversity therefore may be related with the kind of inequality. Social equity, one concept. And often we see race, gender, and other other elements. For example, ethnicity may be discussed in terms of diversity or social equity. However, now some critic may raise and bring the point very seriously about the economic disparity. Often the factors may be implied into poverty. So race, a minority people in race, and a female group, or other people in minority ethnic background would be automatically linked with the poverty. Economic class often need not to be dependent. However, the contemporary context is very imposing, and also now it should be an independent factor to respond with poverty and economic injustice. So I now have some point about which is actually circumstantial, however, may be pertinent in figuring into the First Amendment mandate. So actually, the Constitution is hard to formulate, actually, and the policymakers would often face with dilemmas how to frame the Constitution. However, President Woodrow Wilson once stated, it is very hard to run a constitution rather than devise the constitution. So the First Amendment right was framed into the Constitution as one of a fundamental right. However, in order to run the constitutional mandate, we often be required to look into the nature of practical points, circumstances, environments, and social trend. Science often interplay to what gives a proper scope that the jurist may respond with. So in this case also, you see it is considered to engage that point of highlight, as you see, First Amendment. So you now see the perceptive statement in combination with First Amendment right and also a copyright protection. So the court eventually finds that this factor weighs heavily in favor of a foresight. Another element of the first factor analysis is whether the work's purpose was commercial or had a non-profit aim. So this idea is popular to penetrate this area of concern. So you see, for example, a subsidies agreement in WTO illustrate one of excuse, the educational purpose. The government is prohibited from tendering a financial assistance to others. It contravenes the fair play among the enterprise in the sector. So specific requirement and also other rule and principles were established. And upon that law, we may be granted some of exception, non-profit aim or educational and research purpose may make it vary about national subsidies. However, also the exception may be limited in some point of consideration. You see later reviewed exception and rule in other class. Forsey had a commercial expectation and presumably hoped to find a market for his art. On balance, Forsey's commercial expectation does not weigh much against him. Given the extremely transformative nature and periodic quality of Forsey's work, its commercial qualities become less important. The second factor in the fair use analysis recognizes that creative works are closer to the core of intended copyright protection than informational and functional works. Matters copyrighted by Barbie figure and face can fairly be said to be a creative work. However, the creativity of matters copyrighted Barbie is typical of cases where there are infringing parodies. As they've recognized in the past, this nature of copyrighted work factor typically has not been terribly significant in the overall fair use balance. And the third factor in the fair use analysis asks whether the amount and substantiality of the portion used in relation to the copyrighted work as a whole are reasonable in relation to the purpose of copying 17 U.S.C. 107(3). We assess the persuasiveness of parody's justification for the particular copying down, recognizing the extent of permissible copying varies with the purpose and character of the use. And Matter's point, now you see about the fair chances to avoid the extensive use of a Barbie's image. For example, you see 40 could have taken a lesser portion of his work and also what the entirety of his copyright work in for this use, little added or changed. The kind of argument points to the lack of care, due care, or kind of a wanton or neglect on the fine use of a Bobby image. The court rejected those arguments, and also you see entirely the justice would favor the defendant, since actually the impact on the market would be considered less significant, as you see. It may be related to the commercial purpose. However, more serious aspect in contention would be the kind of a freedom of expression. In balance, the matter's argument has some weaknesses to fully present the cause in balance and just the concept, how to consider. For example, here, because the copyright material is a doll design and the infringing work is a photograph containing the doll. For this, short of severing the doll, must add to by creating a context around it and capturing the context in a photograph. One purpose is for this use, no difference from that of a parodist taking a basic mellow and adding elements that transform the work. In both for this use of the entire door and the use of a dismembered parts of the door, portions of the old work, and incorporated into new work, but emerging imbued with a different character. And the cause, so we do not require parody works to take the absolute minimum amount of the copyright work possible. So the matter's argument is inadequate if we see the nature of a transformation about copyright product. A parody often would be impossible to chill the entire area, entire type of expression in society. How do we see any social comment or criticism to express the political or social ideas? What does a diversity and social equity mean? What is justice? And also, how do we preserve the national identity and disposition in fundament about liberal society? So we now suffer from some of a disorganization of a minor radical political party. It's extreme, and the justice will be delivered soon. And the Prime Minister also focused on that point. That so actually the circumstances would be different. However, you see the extent of a Polish response against communism in the United States. How do you perceive both in contrast, socialism or communism? We now have some unique tradition from German constitution system. See, defense democracy. What does that mean? So we now cannot share same national compassion, for example, with a radical or communist party, or the ethos and basic of this country would be unfriendly with kind of a Sedition Act was subject to public debate, as you see in Korea. Was imported by United States, and United States also managed level of a anti-communist response during Korean War and others. I don't imply the parody may be used to be related with that context. However, it is actually delicate and involves a serious matters on basic framework of nation, freedom of expression. How could we circumscribe the proposition and limitation of freedom of expression? And we see in the next case, Columbia Broadcasting System versus Copy Music Distributors, decided in Eastern District of Pennsylvania, 1983. And in this case, international traders engaged to import the phone records. Phone records, the form that called music, what I now suppose copy music. It may be a principal actor to score the music. So, and CBS, Columbia Broadcasting System, is a corporation based on New York State, and it owns United States copyright to 6 sound recordings, a copies of which comprise the subject matter of copyright infringement case. And Columbia Broadcasting System also incorporates a branch office in Japan, CBS Sony, and CBS Sony entered into a written agreement with Victor Music Corporation, a Philippine corporation by which Victor was authorized to manufacture and sell certain phone records exclusively in Philippines. Later, international traders intermediated the phone records to be imported into United States by way of Rainbow Music. He is the counterpart on the sales contract, and sold the music to international traders and was imported into domestic territory of the United States. So it hints on the lure about a parallel import, a gray market. So as I've said, the two provisions in the statute could be contended, how to harmonize to legalize this transaction. The phone records at issue were acquired outside of the United States by international traders and were imported without authorization from CBS, the copyright owner. So in order to implement the sales contract, it is necessary to obtain authorization from original copyright owner. Actually, the original copyright owner may be bound by a for sale doctrine. So once he agreed upon to use the copyright and a production of a copyright subject matter, then he lost to the entitlement as provided by Section 109. It provides the owner of a particular copy of phone record lawfully made under this title, or any person authorized by such owner is entitled, without the authority of a copyright owner, to sell or otherwise dispose of possession of the copy or phone record. However, we have another provision, section 6002 of the Copyright Act. It prohibits the importation. It goes same way, and it prohibits the importation of phone records without consent of the copyright owner. So it offers the ground about a prohibition of parallel import without consent. So the court weighs in high hand to sustain this provision as the United States importer, who does not deal directly with the foreign manufacturer who buys recordings that have been liquidated overseas, would undermine the purpose of the statute. The copyright owner would be unable to exercise control over copies of the work that enter the American market in competition with copies lawfully manufactured and distributed on this title. So, if on a contrary interpretation, the court so himself constitutes statute so as to alter the intent of Congress. So it is one of a pivotal objective also the Congress intends to lodge in this type of a dispute. In this case, Scorpio argued it is not a proper defendant in this matter because it did not import the records from the Philippines. So he's not an actually he's not a contract party. So international trade is in title of contract as a party. It transacted its business with international trades within the United States. However, the question whether the defendant was the importer did not be resolved. In view of the law regarding vicarious and contributory infringement and the undisputed fact that the international trader was an importer. So he has actual contact with international trade and may engage in deep negotiation about this import and others. And also we may have a construct, some of concept in terms of vicarious contributory negligence. And so actually Scorpio Music now the defendant in this case. Intent is not a necessary element of infringement. And the copyright holder may proceed against any member in the chain of distribution. Sorry, I now exceed my time assigned. The next class will be waiting outside class. So I now, there will be all for this class. And we see the next class in progress about the international aspect of intellectual property rights and other. Thank you for your attention.